So as Grace pointed out, one of the primary sections we'll be talking about and arguing for the modification of is Section 215. Arlen Specter, who's a member of the Senate Judiciary Committee, commented on 215 in 2006, and he is a professor at the Appalachian State University. And in this commentary, he stated that he doesn't think it's still any of the government's business. He doesn't want people to read this and subject of inquiry. What difference does it make? It has a chilling effect, and it's still violating a fundamental freedom of activity. So that's a professor who teaches he's a professor that teaches at the Department of Government and Justice Studies at Appalachian State University. He's stating that one of the sections Grace is mentioning, and we're arguing for the modification of, that there's a key problem with it, and that regardless of previous actions and people that have been killed and why the Patriot Act is in effect, he's arguing that there's still a problem with the fact that it's violating everybody's fundamental rights. Continuing, Sharon Sinner, who's a JD candidate at Stanford in 2008, she commented, in detention under the U.S. Patriot Act, a court considering a procedural due process claims to ask first whether an individual has been deprived of a protected liberty or property interest, and second, whether the procedures have provided other sufficient protection against a wrongful deprivation. So she's stating that there's additional problems with due process being violated, not just facts that the language is vague in sections of the Patriot Act. From the impact of the U.S. Patriot Act on collection and analysis of personal information under FISA, authors Paul Yeager and John Berteau state that there's no doubt, however, that the Patriot Act is currently having a significant impact on the collection of personal information under FISA. However, this impact is just going to increase with the proposed revisions. And since 2004, those revisions have been in place. And how those provisions were put into effect was because the original bill to revise the Patriot Act, specifically Section 215, it was supported by a diverse group of liberal and conservative groups, including the ACLU, Gun Owners of America, and Free Congress Foundation. In 2006, when the ruling passed for the modification of Section 215, the time limit was already reached, and it was extended 15 minutes at a vote of 219 to 201. However, at the the initial vote, there was a 23-minute disparity, and so the House of Representatives, until the Bush administration was put into effect and the Republican leadership was suspended, they suspended the voting rules so they could convince additional counsel to change their minds, so that when they did extend it for 15 minutes, they were able to get it revised in their favor. A professor from the Appalachian State University, Victor Marrero, was a federal judge that commented on the professor's statement, and he ruled that the provision allows the FBI to issue itself national security letters, which is part of Section 215 that needs revision, and how those are unconstitutional because the FBI demands information from internet service providers without judicial oversight or public review. And that was in 2009 that judge made that comment. Another judge, Judge Collins, rejected a different section, Section 805 of the Patriot Act, and she ruled that the court finds the terms training, expert advice, or assistance in the form of specialized knowledge and service impermissibly vague under the Fifth Amendment, and hence Section 805 additionally needs revision. Although this U.S. Supreme Court acknowledged President Bush that he has the authority to declare every American citizen as enemy combatants, it ruled that even foreigners be given access to American courts and be accorded some type of due process to determine their merits to their legal claims, as well as their federal violations. Newt Gingrich, he was asked in a survey that was also done by the Appalachian State University to answer the question regarding if he is in favor of revision or against it. He responded with, I think that when you're trying to restrict the power of the state, there's a broad coalition that shows up on some side of the philosophy, and that you've got to decide what you really want the level of power to be, whether it's controlled by political figures or the individual's rights. And then one last comment. Former House Majority Leader Dick Armey, who is a very conservative congressman and usually voted against reform for the U.S. Patriot Act, he stated that the Justice Department seems to be running amok and out of control, and that this agency, referring to the federal government, is the biggest threat to personal liberty in the country. He made this comment in 2006.